Welcome, everyone. My name is Corinne, and I will be your moderator this evening. Lee Tessler with Cirrus Consulting Group is our speaker tonight, and he will be discussing 3 critical lease clauses to protect the future of your practice: relocation, assignment, and option to renew. If you've attended a previous webinar with us, you may have noticed that our in-webinar console has changed, and I would like to highlight some features that will enhance your viewing experience. To contact Lee, click the envelope icon under the speaker box. If you have a question, please type it into the box labeled "Have a Question." To talk with other attendees, navigate to your control panel at the bottom of your screen and click the chat icon. Finally, Henry Schein is not offering CE credit for viewing or attending this presentation, live or on demand. Lee, welcome, and thank you for being with us tonight.
Thank you, Corinne. Thank you for having me. Let's get into the webinar then. So the purpose of today's webinar is we're really going to look at some of the legal provisions and how to avoid $100,000 mistakes through these 3 specific clauses: the relocation, the assignment, and the option to renew clause. There will be some updates in terms of current market and opportunities available. We will go into some of the technical side of the lease and the legal provisions so that we can look to give some advice in terms of how to protect your estate and your family. And we'll talk about some of the common mistakes when approaching a lease negotiation. So I think it's important for you to understand a little bit about who Cirrus is and how we've been representing the dental community now for over 25 years. Essentially, we're a healthcare and dental specialized tenant representation firm founded by dentists for dentists. Over 25 years ago now, we've negotiated over 12,000 leases since inception, really because landlords were taking advantage of this dental and healthcare tenant. And as many of you know, it's an expensive business to enter into, but also very profitable business. And when it comes to transitioning, especially. So what makes us unique is we do everything in-house. We do all the financial and legal negotiations of the lease. We have an in-house legal and leasing team comprised of real estate attorneys, some with a background in healthcare, some former real estate brokers, and some actually that we've hired from the dark side, the landlord side. We do lecture at most of the major dental convention centers, the Pacific, the Greater New York, California Dental Association. We really do work with dentists nationwide. Now, I have to just read a small disclaimer in terms of some of the market updates that I'm going to read. That there's no guarantees or of any sort of future predictions in terms of some of the statements that I'm going to read to you. So in terms of just a general national market, if we look at this year on year and availability rate. Now, obviously in the last couple of years, the availability rate has gone up in terms of a percentage, and some of the retail market has suffered from COVID, and a lot of businesses and working from home or in a hybrid space, that a lot of the spaces have become more available. Some of the tenancies, as you may well know and see. If we look at just some of the different kind of markets, Chicago, Illinois, for example, and just national in US, you can see from the blue line that looks at what the market rents have been doing and what they're predicted to do after 2022 and 23, 24, and so on. And then the yellow line, we're talking about some of the vacancy rates. So you can see where obviously vacancy rates started to go through the roof when COVID came into effect a couple of years ago. But now we've sort of come out the other side. You can see rents starting to increase and vacancy rates are starting to flatten off now. So we're starting to see people taking advantage of opportunities. If there are spaces available that maybe they didn't believe were available, or there's some new spaces or retail strip plazas or medical buildings that people have moved out of. People are taking an opportunity to take advantage of attractive incentives from landlords. As you'll see in Houston and Jacksonville, the trend is very similar. And what I would say from my experience now is, yes, if you're building out a new practice from scratch, then there's still incentives for landlords to have a dental tenant in a space. But if you are an existing tenant and you're looking to, a straightforward renewal, landlords are still very unlikely that they want you to be paying rent at less than what you're currently paying. And predictions are that rents will still continue to increase, especially with inflation. And as you can see in LA and Nashville, again, majority of the rents prediction is that that's going to continue to sort of go up over the next few years. Same for Seattle and Washington. Vacancy rates very similar around 2020 to the top of 2021. They've started to plateau now, and again, rents are still demand in some of the high net worth areas. There's still lots of demand. So this is just a sample. We have access to lots of proprietary data here at Cirrus that we pay for. So we certainly offer a complimentary consultation as we go on a little bit further down the line. So you have to take into consideration your own specific location, your own specific space. Every individual scenario is different, and it's relative to your own situation. So we can certainly really take a deeper dive into your current space, your current location, see what the actual vacancy rates and the rental rates are there, and we do have access to a lot of that information. So what is a lease? It's one of my questions that I always ask at all the seminars and webinars that I've been doing the last couple of years. Normally I'm in a room with a live audience, which is always a little bit more interactive. We try and make this as interactive as possible. But I do ask the question, what is a lease? Now, I'm going to give you the answer myself. A lease really is a check, and it's one of the biggest checks that you will write in your professional business working life, maybe aside from your residential purchaser property. It really is a check. If you're signing a new lease and you are committing, a 2,000 square foot space, and you're paying $5,000 a month in rent, the average dentist will stay in their space, and statistically, the average dentist stay in their space for 22 years. Now, even if we just look at that, we don't look at any rent escalation, any inflation, any operation, additional expenses, just taking the gross payment of $5,000 a month, that's $60,000 per year, $600,000 over 10 years, and $1.2 million over 20 years. So if anything I would like you to get out of tonight's presentation is, I don't expect to make you experts, but I want you to really walk away and understand, one, how important the lease is to your business and your practice, and two, how important you as a dental tenant and how valuable you have become and you are. So everything is negotiable, but we're going to give some of the tips and tricks to help put you in a better position for now and for the future of your practice. So in terms of the financial negotiables in your lease, again, just to, from a high level perspective, we have 7 different variables that can actually affect the financials negotiations of your lease. You have the base rent, annual increases. Like I said, at the moment, we're seeing inflation, going through the roof, and some leases that may be in line with inflation over the last 20, 30 years, you know, you may have gone up 2-3%. Now you're starting to see a little bit more effect on those increases. So there's certain things that we can do to either fix the rent for a period of time or cap the actual annual increase. We also talk about the common area maintenance, the additional operating expenses. Majority of leases nowadays are a triple net lease, whereby the landlord will charge you a base rent plus the additional expenses for the tax, maintenance, and insurance. There are, depending on if you're building out a practice from scratch, there's a fixturing period. You want to make sure that you have some free rent during the fixturing period before commencement. Is there any tenant improvement allowance, and what sort of landlord work are they going to do as well? We want to make sure that they have some skin in the game as well. Now, this slide, I wanted to just touch on buying versus leasing, because there may be some of you tonight that actually own your own building, for example, and I just wanted to give you, a lot of people ask me, what are the sort of pros and cons of buying versus leasing? So there's a couple of things I wanted to talk about. First of all, buying a building, if I have $1 for everyone that says to me, I want to pay rent, I want to buy my own building, and 5 years later I've spoken to them again, they're still leasing, they still haven't been able to buy that dream property. And that's not to say that it can't come to reality, but it's an expensive real estate, and if we could buy our own space, then wonderful. But there are other things that come with that. Not just a large upfront investment, but then you become a landlord. You do have the greater flexibility on how you use the space. Being your own landlord, you don't have to report to anybody, and you can do what you want. You have the freedom and the control of the property. In terms of some of the cons, or why people lease, you don't have to put in such a big upfront financial investment. You can have a greater working capital to not just to build out of your practice, but to also have the practice scale and grow, and also you're not tied to that location. If you buy your own building and for whatever reason the landscape changes in that demographic, or it becomes not such a great community for whatever reason, you're stuck at that building rather than having the potential flexibility to relocate. So, I mean, the main thing here is that the common ground really is, even if you do own your own building, it's still extremely important to have an office lease that separates the building from the practice, because in the future, who knows, you may decide that you want to sell the practice and actually keep the real estate and become a landlord. You may want to sell both the building and the practice, but an associate or somebody else may not have the finances to actually buy both the practice and the building. So if you are going to stay and be that landlord, what sort of control do you want over your asset? What type of person do you want to come into that space? And what happens if they decide that they want to sell in the future? So it's still extremely important to have the dental office lease, or the arm's length lease, as we call it, between the building and the practice, if you do own the building. So now we're going to take a little bit of a deeper dive into some of the critical clauses within your lease. Now, there are at least 20 to 25 provisions. Some there are higher priority items than others, but what, from my experiences, majority, and again, we'll look at what they're paying, for how long are they paying it. They'll look at the first page of the lease, and the other 30 pages will go in a drawer, and they'll look at it again in 5 or 10 years' time when the lease comes for expiry. And that's where some of the mistakes are made in terms of reviewing the lease. So we're going to take a little bit of a deeper dive into some of the, 3 of the critical clauses that could have a real detrimental effect on your practice. We'll start with the relocation clause. Now, a relocation clause really is an option granted to a landlord to change the location of the tenant's premises upon the landlord's provision of notification. Now, one of the things that we want to do, if there is a relocation clause, I mean, best case scenario is to remove the relocation clause. But it doesn't necessarily mean if you do have a relocation clause in your lease that you still can't protect certain expenses and moving and relating costs to the relocation clause, because in some places, if it's written correctly, the landlord is still responsible for any associated costs that will come with, improving or relocating the space. So I wanted to just give you some sort of sample of some of the language that we see. Just take a minute just to have a look over this lease. This is basically one provision that we see that's common in the relocation clause. And we're going to just go through just to give you an idea of some of the red flags. So, landlord may at any time upon 60 days notice relocate the premises to a reasonably comparable inside. Tenant will reopen for the business to the public in the new premises by the date set out in the landlord's notice of relocation. So, I mean, already there, 60 days. If you were given a letter from the landlord saying that you had 60 days notice that they're going to relocate your premises. Now, if any of you have moved or built out a dental practice, relocated, 60 days is certainly not enough time to make a reasonable move to another space within the premises. It still talks about reasonably comparable in size. So, not only can you be relocated, but you may be put in not such a more favourable space within the premises. You may have had a first floor office space. You may be a third, fourth floor. You may not have great access. A number of things, but the 60 days already is a big red flag. And then if we look at here, section B, it says, if premises are relocated, the lease will remain unchanged, except that the rent will be adjusted based on the GLA of the new premises. So they can relocate you and they can adjust rents accordingly. So there are a number of other things here. The landlord will reimburse the tenant for reasonable costs and expenses. But again, it's all reasonable costs. What are reasonable costs? If you've got expensive cabinetry or equipment, what is reasonable? And then the final provision, is the final paragraph at the end said, notwithstanding the provisions here are to be construed broadly in favour of the landlord. The tenant objects to the relocation of the new premises. The landlord may elect to terminate the lease on 30 days written notice. So not only if you have that relocation clause in your lease, in whatever notice period you have, if you object to the relocation, they can actually just terminate your lease. So if they want to put somebody in your space that wants to pay them more rent, and they have that relocation clause, what effect is that going to have on your business? Now, what's the cost of this mistake? Now, having to build out a new unit, the cost of practice downtime, reduction in the appraised value. I mean, ultimately, this could cost upwards of $300,000, $400,000 just from having a relocation clause in your lease. So there are a number of step downs. There are a number of things that we've been successful in negotiating. Best case scenario is removing the relocation completely, but If we are unable to remove it, then we want to at least extend some of the notice period, because 60 days is, as you can see, is not enough time for anyone to relocate a dental practice. The second provision that I wanted to touch on tonight is the assignment clause. Now, the assignment clause really is, it allows the landlord permission, normally in conjunction with the sale or acquisition of a practice, but the actual definition is to transfer another party or of all a tenant's interest in a lease for the remainder of the lease term. Now, this is an extremely important provision, especially when you're coming up to your planning for transitioning or selling the practice. Now, as we'll see when we look at the assignment clause, one of the provisions in the assignment clause coming up, this is structured correctly, then that can really just allow for a smooth and a clean transaction from one practitioner to another, and any sort of continuing liability. If you sell the practice, you want to be released from any further liabilities. But anyway, let's dive into an assignment provision. And now this is found in 75% of dental leases that we review on a daily basis. Again, take a minute just to have a read through this, and bear in mind I read through probably 3-4 leases a day. So I'm going to give you a minute or so just to have a quick read through this lease, and then we'll touch on some of the language and the red flags that we see on a daily basis. Okay, so the first section says, if the tenant should wish to assign or sublet the premises, it shall first have received the consent of the landlord. Now, this is very common. The landlord is going to want to have some say in who is going to take over their space. They're not just going to let any individual, any person just take over the space. So consent is normal. What we're looking at is what does that consent look like? Can it be delayed? Can it be unreasonably withheld? What are the restrictions or conditions that can be put on in the lease? Now, the first thing you can see here is you've requested permission to transfer the lease. And in this lease, it says the landlord shall, 1, approve your request to assign the lease, 2, simply decline your request to assign the lease, and 3, can actually terminate the lease agreement upon the effective date of such proposed lease assignment or sublet. So right here, just from you asking for permission and the landlord declines, this is what we call a termination provision. Just from asking permission, the landlord can actually just say nope and terminate the lease agreement. So suddenly your practice you've spent 20, 30 years in, the foundation and the location, yes, you may be able to sell some of the goodwill and the equipment, but terminating the lease agreement is going to have a huge effect on the value of your practice. Now, if you see here, landlord shall have the right to revise the minimum rent to be paid during the remainder term to the greater of the current market rent for the leased premises, or 15% greater than the current rent. So you ask for permission to transfer the lease. And the landlord says, sure, no problem, but just to let you know, the rent's going to be increased by 15%. Now, if I'm the buyer that's looking at buying your practice and doing my due diligence, and suddenly I'm going to get a 15% increase on rents, the first thing I'm going to do is probably reduce my offer by 15% to buy your practice. And again, these are common things that we see in leases on an everyday basis. So furthermore, should tenant receive from the assignee or subtenant any rental income, cash goods, or any form of consideration in connection with the assignment, then over and above the current base rental rates payable to the landlord during any fiscal year, the difference between the annual rent and such income or other considerations shall be paid directly to the landlord. Now, a lot of leases that are written, they're not written for a dental tenant. Here is what we refer to as consideration language or proceeds of sale. We work with a doctor who had agreed a really beautiful practice, was producing around $2 million per annum, and he was just, in the process of dotting the I's and crossing the T's, asked the landlord for permission, consent to transfer the lease, and the landlord said, sure, no problem. And the landlord wanted 50% of the sale proceeds. 50%. We're talking around $1 million just to grant consent, just to approve the assignment of the lease. This doctor had gone so far down the line with the buyer. In the end, he wrote a check for $132,000 to the landlord because he didn't want to lose the buyer, to have the lease assigned. In his lease, he had language that the landlord was entitled to 50% of the proceeds of sale. So you can imagine. Now, notwithstanding that the landlord's consent to assign or sublet, the tenant shall not be released from its obligations under the lease and shall remain liable for any failure of the tenant or its assignees or subtenants to observe each and every covenant of the lease. Now, let's say that we've got through the consent, there is no proceeds of sale, then the landlord can say that you're taking on, I'm approving the assignment, the transfer of the practice to, a young associate that I don't know very well, and you are going to remain continually liable for any obligations under the lease. Now, if that buyer was to, default or go, bankrupt, and we had a client that was retired, and he got a phone call from the landlord 3 years after retiring saying, hi, sorry to be the bearer of bad news, but your buyer took on too much debt and he has declared himself bankrupt, and he's 3 months in arrears of rent. You owe that rent and the remaining 7 years term of the lease. The last thing that doctor wanted to do was come out of retirement and go back to practicing. Again, there are a number of step downs. There are a number of things that can be written into a lease to ensure that you are able to sell the practice to an accredited dental practitioner, and not just to anyone. And best case scenario, you should be removed from any future liability. In some cases, you may have to provide 1 or 2 years of continuing liability, but what you don't want to do is provide that continuing liability forever and ever. Amen. Now, as you can see, this is just one provision, the assignment provision, one paragraph. There is 5 red flags here, and the cost of this mistake: inability to sell the practice, having to absorb a significant increase in rent, remaining liable as a guarantor beyond the practice sale, paying a portion of your proceeds of sale. this liability is anywhere between $250,000 to $750,000. Now, we don't want to leave any money on the table, and we certainly don't want to give any money to the landlord when it comes to selling the practice. The last provision I want to talk about is the option to renew clause. Again, just to define the option to renew clause, a lease provision that gives the commercial tenant the right to renew the current lease for additional terms subject to the clause and conditions as set out in the lease. Now, again, we always recommend having that sort of runway, whether it's in term or in options. It's important to have that peace of mind and security, knowing that you have a certain amount of runway and term left, at least, to give yourself the option. Some mistakes that dentists have made, they'll have a lease that's coming up to expiry, when they're 65, and they think that that's the last lease I'm going to sign, and I'll sell the practice then. I don't want to commit to any long term because I'm going to sell the practice, which is generally a mistake. Now, that doesn't mean at 65 you want to be signing a 10, 20-year lease, but if you're in a good location, if you have a good demographic, a good high net worth practice that you're confident that you'll be able to sell, then as long as the lease is structured like we talked about in some of the assignment language, then there's nothing wrong with having that additional term going forward. So again, just I'll give you a minute or so just to have a quick read of this paragraph, and then we'll touch on some of the see if anyone see any red flags, and we'll go through some of those. Okay, so let's start with the option to renew, which is found in 90% of leases. So, provided that Dr. Joe Black shall remain as the tenant, and if the tenant duly has regularly paid its rent and performed its covenant and obligation under the lease and has not been in default. So the first thing that we can see here is provided that Dr. Joe Black shall remain as the tenant. Now, what I've seen in a number of cases where savvy landlords, what they'll do and what they'll say is, I'm giving options to you, the tenant, and they are personal to you. They're not transferable. So I was speaking to a doctor recently who was looking to sell his practice, and he told me that he had 12 years of term remaining. When I actually got a copy of his lease, what it turned out was that he had 2 years remaining of term and 2 5-year options, but those options were personal to him and non-transferable. So landlord will say, I gave those options to you, I didn't give them to any future buyer. And again, this is just some of the tactics that a landlord will use to give them the leverage to say, well, if the new buyer wants some additional or wants those options, then it's going to have to pay higher rents or whatever that they want to do with those options. So it's important to understand and to have the options that can be transferable as well in the future. So it says here, and it's important just for you to know, like you'll have an option, you will have a time period, normally sort of 6 to 9 months prior to the end of term, where you have to give notice. If you don't give notice, those options become null and void, and a lot of times the landlord won't tell you when those critical dates are apply. And And as you can see here, it says any such renewal shall be on the landlord's then current standard form lease. So if we've negotiated or if we've made some changes to the lease, which I've seen on a number of occasions, we've represented the client, we've made some amendments to the lease. For whatever reason, they've exercised the option in the future. The landlords then just put them back onto their standard form lease and inserted, in some cases, a demolition clause or whatever they wanted to do, just purely because of the renewal language saying that they can go back on the landlord's current form lease. This one is a favour of landlords. In no event shall the rent be less than the rent paid in the last year of the original term. As I said earlier, very unlikely that the landlord wants you to pay less than you've been paying in the original term. But, in certain circumstances, recession, COVID, there's certain circumstances that the last year you may have been paying, high rents, and there's been a crash in the market. So you don't want to be. You don't want to have the option to at least renegotiate some of the financial terms of the lease. If there was a recession and markets have dropped 10, 20%, you want to see some of the benefits and at least be able to, the landlord can't just keep no lower than the year previously. And the last sentence of this paragraph says, if the landlord and tenant are unable to agree on the market rent within 60 days of the exercise by the tenant of its option to renew, the rent shall then be determined by arbitration based on market rents for renewing tenants in the building. Now, there may be Walmart, there may be Starbucks, there may be big tenants that have renewed in the building that are paying a lot more rent than you're currently, paying, and shouldn't be compared to renewing tenants in the building. Again, another provision common in 90% of leases that I read, and you can see here there's 4 or 5 red flags that can have a huge cost and liability to your practice, where you're looking at sort of 200 to 500,000 liability. Having to relocate unexpectedly at the end of term, inability to sell the practice. Majority of any buyers are going to need at least 5 to 10 years of term when it comes to them buying your practice. They're going to need to, a bank's going to need them to amortize that loan over a certain period of time. Now, this is actually a copy of a letter that we were privy to, that a landlord actually wrote to a client, basically just pointing out when they missed their option to renew, that you were required to give written notice of your intention to renew not by 6 months. You were required to do this no later by this date. Please be advised that we'll be placing a for lease sign on the premises. We'll only show the prospective tenants during business hours, and they will attempt to contact your office. So this was a landlord, a lovely landlord, that waited, or once the tenant had missed that option, was sent a notice saying that we're placing a for lease sign. So you're suddenly seeing patients, and there's a for lease sign outside your space. How do you think that's going to go across to current patients that are coming to see you? And a lot of questions are going to be asked to start showing the space around to other potential tenants. Now, like I said, for the interest of time, there's lots of other provisions that can really cause a detrimental effect to the practice. We touched on the assignment and the relocation and the option language. There are other, demolition, death and disability. There are some other personal guarantee. There's lots of other languages, again, in the lease that can really have a real detrimental effect on your lease. And a lot of these are hidden. You wouldn't really know or see them unless an expert had pointed them out to you. So this next slide is a slide that I actually pulled from one of my lease negotiators, like I said, who used to work for the landlord. This was a slide which I like to show on all my presentations. It's a tenant lease cycle. So what we have here is we recommend that you start the process at least 2 years before your expiry. So if your lease is expiring, you may have some options to extend. Now, lots of people, again, make the mistake to say, well, I've got an option to extend. I've got to give 6 months notice, so I will speak to them 6 months before, and then I'll just exercise the option. Now, there's a couple of things with that. One, depending on what the lease looks like, just by exercising the option, you really are agreeing to not make any changes to the lease in terms of the legal provisions that we've just talked about. Yes, there will be negotiations on the financials and the rent and the term, but we recommend that we start the process at least 2 years before expiry, certainly within that 2-year window, because that gives you the best leverage to start the negotiation. Now, a landlord may say, oh, we've got plenty of time, no problem, let's talk about it next year. What they want to do, as you can see by this slide, they want to get you down to these sort of 8 months, get you closer to the expiry date, because one, they know the nearer you are to the expiry date, realistically, the less likelihood you're going to have enough time to, even if you didn't like what was being offered to you, the likelihood is you're not going to be able to move. You're not going to be able to relocate a practice, because that can take a year. And even if you want to or don't, you do not want to move, whatever happens, that again, it's a lot of strategic play in terms of the approach to the landlord, because as far as they know, they don't have to know what your plans are. But if something was to go wrong, or you didn't like what was being put in front of you, at least you have time to say, well, I'm exploring some other options. If you have an option to extend, you know that you have that in your back pocket. But if you start the process 24 months before, or at least 18 to 24 months before, just gives you the most leverage when it comes to renegotiating. So it's important just to know the critical dates, when your lease expires, if there is options, when are those critical dates. And again, these are things that we can monitor for our clients and make sure that they're well ahead of the time frame. Now, why, you're probably asking, all these detrimental legal provisions, like how Cirrus and how have we been so successful winning lease negotiations for over 25 years now. We're very proud to be, the preferred business solution partner for Henry Schein for over a decade, really because they were looking for somebody who could look after their clients when it comes to the lease, because they know that a number of issues that their clients have had, having to be relocated, having that there's a demolition in their lease clause in their lease, which cause a real problem in the practice. So, what the reasons what we're successful is, first of all, what we do is we gather all the documentation. We get all the copies of the executed leases, any amending agreements, riders, exhibits, anything pertaining to the lease. We would then spend time just to understand and identify some of your, career and practice goals, where you are now, where you want to get to in the future. If you're happy in the space, if you're at capacity, if you want to look at expansion, just to understand exactly where you are. We will then review the office lease for any risks and any liabilities. Like I said, we go through the legal provisions with a fine-tooth comb. We then prepare market research. We pull up some of the proprietary data that I mentioned, just to get a good understanding of the landlord. Is it a big institutional landlord? Is it a mum and pop? Who are we dealing with? And then, we develop a strategy for the negotiations. Now, so one of the things that we haven't done here at these sections, we've 5 things we haven't even approached the landlord. Now, one of the biggest mistakes, and I strongly suggest that even if you're thinking, I need to look at my lease, have I got all these things in my lease? The last thing you should do, first of all, if you do have or anything, is to ring up your landlord and start asking questions and, can you take this out of my lease, or what's this in my lease? Like that, candidly, is a mistake. There's a reason that we do a lot of these 5 steps before we even approach the landlord. So we have a good understanding of you, of the market, of the current location. And really, it's just about educating the landlord, because, like I said, you're a good tenant, you pay your rent, you have some of the lowest default rates in the country. Why wouldn't a landlord want to do their utmost to keep a tenant that stays in their space for over 20 years, like I said, pays a lot of money in tenancy expenses? Why would they not want to keep you, becoming more and more of the anchor tenant these days? So a lot of it is just educating the landlord to explain, look, there's certain provisions and certain clauses in the lease that we would want to address just to protect the future of our practice. Now, none of that, we're remunified directly by the client. We're not asking the landlord for any commission or anything. And more times, landlord's very happy. And we appreciate that, you've still got to work with the landlord in the future. So in many cases, we actually improve the relationship. The landlord doesn't always directly want to deal with the client. So once we've approached the landlord, we would normally spend 20, 25 hours on the lease, on the negotiation, on the economics of the financials, the rent, the term like we talked about, rent escalations, and then the lease negotiation terms. From our experience, once we have a motivated landlord on the financials, because really what they're looking at is, who's my tenant, how long are they going to be staying here, and how much are they paying? And once that ticks a number of boxes, they're very much more motivated to make some of the changes to the legal provisions of the lease. And then we would review the final executed lease documents for your benefit, just to make sure everything's good. I just want to remind everyone, we will have a question and answer section just towards the end of the presentation. But there are, if you do have some questions or anything you're thinking, you can submit them in the chat. I will, like I said, I will spend some time going through some questions and answers, but feel free to use that facility. Now, these are just some of the latest Google reviews. Now, this was from a doctor who literally, the landlord, the lease prevented from selling the practice 3 times. At 74 years of age, the landlord, he was forced to relocate the practice. 74 years of age. He tried to sell 3 times, and the landlord found a way to, scare them away. We helped relocate the practice, got a much better space, and the landlord covered 100% of the build-out costs. and the client was able to secure a longer term lease, which he was then eventually able to sell in the future. You can see there's over 200 5-star Google reviews. So what we have here is what we call a critical dates and risk analysis. It's a $1995 value, where we would spend 3 to 4 hours analyzing your lease for any traps. We would then get on a scheduled call, go through your vision, identify some of the liabilities in the lease, and come up with a strategy to negotiate a tactical plan. This is a really beneficial 3 to 4 hours. So if anyone's interested in this critical dates analysis, we are, thanks to Henry Schein, we are offering that as a complimentary, thanks to our sponsors, Henry Schein. So this is really on a first come, first served basis. So I would strongly suggest, if you are interested, you can put you'll see we have some polls. So if you are just some polls to end, if you can spend a little bit of time just to answer some of these questions. But if you are interested in the complimentary lease review, again, we're just a couple more poll questions for when we exit. If your situation is urgent, please make it clear. And if you are interested in a complimentary lease review, I would strongly suggest you take up this offer. Like I said, it's on a first come, first served basis. That's my direct number. You can, if you do have a digital copy of your lease, send it to info@cirrusconsultinggroup.com. I will spend 3 to 4 hours going through your lease, and we'll go through some of the areas of concerns, liabilities, understand a little bit more about your plans for now and the future, come up with a treatment plan, a strategy moving forward. As we have around 5 or so minutes for some questions and answers. So,
thanks, Lee. Yep, we do have a few questions in the inbox.
Okay,
so
I think I can see
them. First question asks, please elaborate on holdover. Any holding over after the expiration date should be construed as a tenancy at will at a fixed rent equal to 150%. Can you elaborate on that?
Yeah, so a holdover provision really just protects the landlord if you are in a lease and your term expires. Technically, you become a month-to-month tenant. So it's very common in a landlord to put in an overholding provision whereby you will have to pay, in this scenario, 150% of the rent, or increase sometimes 1 or 2 times rent, because for having the privilege or the flexibility of being a holdover tenant, essentially you can give the landlord 30 days notice that you're leaving, and that could certainly leave the landlord in a position where they have, a space that might take them 6 months or a year to fill that or backfill that space. So for the reasons of both parties, if you don't want to, if a tenant doesn't want to commit to a long-term lease and wants the flexibility of being holdover, then the landlord wants to get paid an overholding provision. So it's quite common in that respect.
Okay, great.
I hope that answers the question.
Yeah. And then Roger also commented triple net and paying a part of taxes. Can you elaborate on that? Do you have any thoughts?
Yeah, I mean, like I said, I mean, the majority of leases nowadays, if you are fortunate to be on a gross lease, which what that means is what you will pay a certain amount of money a month, and that will include all the tax, the maintenance, and insurance. Nowadays, the triple net lease is what landlords certainly want to put. Landlords want to put their tenancy on. In terms of, I'm just looking at the actual specific question, which I don't know where that's gone now. In terms of, I can't see the question now.
Triple net and paying a part of taxes.
Yeah, so I'm not 100% sure. I mean, I could speak to that person in a little bit more detail about their own personal situation, but triple net essentially is what it says. You will pay the tax, maintenance, and insurance. The tax and the insurance is normally not very negotiable, and that goes up every year. The maintenance is something that we look at just to make sure that there's at least transparency and accountability to what you're actually paying for.
All right. I think that wraps up our questions this evening. So thank you, Lee, for the excellent information on tonight's webinar. And thank you to everyone who attended. I hope everyone enjoyed tonight's webinar. We would appreciate your feedback via our survey that will pop up on your screen shortly. We did record tonight's webinar, so we'll email the recording out via email sometime in the next week. And lastly, if you're interested in attending future webinars, visit www.henryscheindental.com/webinars for our upcoming schedule. Thank you all for joining us, and thank you, Lee. We look forward to seeing you on future webinars.
Thank you very much. Thank you, Corinne. Thank you very much, everyone, and have a safe, have a good evening. Thank you for your time.
Thanks, Lee. Bye-bye.